Hi friends, this is Suman Dash Bhatta-Mishra, Assistant Professor of Law at National Law University, Odisha, Cuttack, and I am here today to discuss with you one of the modules of your course in Advanced Jurisprudence. The current module has been titled as Gender Orientation of Law in India. So as we begin, let me first introduce you to the topic. Now, before we begin an understanding of gender orientation of law in India, we need to understand the context in which the module has been designed. Keeping that in view, we must first ascertain what is the necessity of law in the life of a society and how law is best understood in a social context. It is important for us to understand that law is a major instrument of social change, and at the same time it is best understood in a social context. The spirit of equality of laws is a necessary prerogative in any and every social system. When we talk about equality of laws, it is but necessary for us to understand that gender is a major issue and a primary concern in every social context. In India, laws lack an understanding of feminine psychology and are often gender insensitive. It is with this view that we have designed this module, and I am trying to introduce you to the idea of gender sensitivity. An understanding of gender concerns is important to prevent the legal system from discriminating between individuals on irrational or unreasonable grounds. And this is where I am trying to introduce you to the objectives of the module. The first objective of this module is to acquaint students with the necessity of gender sensitization in law. The second important objective of this module is to inform them of the special provisions made for women under various legislations. The third important objective that we have for this module is to discuss the historical reasons behind the enactment of those special provisions. The fourth objective is to describe and carefully analyze the impact of existing legislations on the rights of women. Finally, the objective of this module is to stimulate a critical approach towards existing laws so that they can reflect on the pros and cons of existing legal provisions. So, now that you are well acquainted with the objectives of this module, let me introduce you to the very first concept that I have tried to address in this module. So, the thing that we are now going to discuss is the interface between law and society and how concerns for gender have been encapsulated in India. So, the thread that links law, society and gender in India is unique because the Indian society has a unique structure. Primarily, Indian society has been patriarchal in its structure. Historically, we have had patriarchy prevailing in the Indian system of society. Not only that, we have had traces of matriarchy, but they were nominal and often not regarded as a matriarchal system. Now that patriarchy forms the most important facet of Indian society, the laws obviously were always oriented towards addressing problems of men and always took into cognizance male or masculine psychology when they were being formulated. No doubt, we did have, as we have even today, certain legal provisions for Indian women as well. However, they were at the end of a long and arduous struggle. So, women in India have confronted several disabilities, starting from the sati system to the parda system, lack of education and basic civil rights. So, since sati, parda system, lack of education, lack of basic civil rights existed in the Indian society, it was necessary at the same time to put women at par with men. This is where during the Indian national movement, social reformation movements started becoming popular and also significant in determining the course of Indian history. So, the positive impact of social reformation movements during the Indian national movement was seen because of the tremendous contributions made by Raja Ram Mohan Roy, by Swami Dayanand Saraswati and several other social reformers like Rabindranath Tagore, who believed in the existence of a social system where women can claim to have the same rights as men. That being the system and them having fought a very long battle to protect the rights of women, Indian women started gaining gradual recognition of their rights in the system. Fighting against men for the basic of their rights became a dominant feature of the Indian society. Now, after the Indian national movement, when India had gained its independence, we then adopted the Indian Constitution in the year 1950. The adoption and enforcement of the Indian Constitution was a major watershed in the rights of women and in the feminist movement that India was witnessing at that period of time, because under Article 14, the Indian Constitution guaranteed the right to equality to all citizens of the country. Now, the spirit of equality which pervaded the supreme law of the land was sufficient to ensure that Indian women are treated at par with men. Not only Indian women, but also people with other gender identities had to be treated as equal, because that is what the Constitution, the supreme law of the land, guaranteed. Now, after this background, it is important for us to understand the special legislations which came to surface for protecting the social status of women. And yes, when I say social status of women, I am using the words very carefully, because Indian women have had to fight very long and hard, not only Indian women, but also Indian men who believed in the supreme equality of women with men, have had to fight a long and arduous battle, a battle that was in search of the identity of the status of women. Recognition of social status was important, no doubt, and this is where we had to bring in the law. It is surprising to notice that in a land where women were worshipped as goddesses, where mothers and daughters, sisters have been respected and regarded by the country, even in a country like that, in a land like that, we did have to formulate the law, which is an agency of social control, for the purpose of ensuring that the social status of women is safeguarded. So, let me begin with one of the earliest legislations which came into the picture for safeguarding the social status of women. Let me begin with the Bengal Sati Regulation Act of 1829. Way back in the 19th century, we had the then Governor General, Lord William Cavendish Bentinck, who worked tremendously for the protection of the rights of women who were being immolated on the funeral pyres of their husbands. Sati as a system, as an institution, had become a very distinct and prominent feature of the Hindu society then, and social reformers like Raja Ram Mohan Roy and Dayanand Saraswati had waged a serious battle against this particular institution, because it was considered to be degrading towards the health of the Indian society as a whole. The objective of Sati was manifold. It brought about many returns for those people who wanted Indian women to be oppressed, and at the same time it brought returns and unjust enrichment also towards those people who wanted to take away the property and other rights of women as a consequence of them being immolated. So, the practice of sati was a shame on Indian face, and at the same time the then Governor General Lord William Cavendish Bentinck decided to go for the Bengal Sati Regulation Act in the year 1829. The act was significant because for the first time we had a legislation in the country which defined the term sati and it was followed by a very special legislation which was enacted by the center, which was called the Commission of Sati Prevention Act 1987. So, followed by the 19th century enactment, we then move on to the 20th century enactment, which has similar provisions as that of the 19th century enactment, but is a legislation which is intended to prevent, prohibit and punish the practice of sati in its most varied forms. So, by the Bengal Sati Regulation Act, sati was prohibited in the whole of British India, that is, in all jurisdictions where the British could have operated in India. So, the Commission of Sati Prevention Act, the current important legislation which was enacted in the year 1987, defined sati and also punished the practice of sati, followed by something called as the glorification of sati, which was also equivalent to the abetment of sati, and aiding in the commission of sati was also prohibited under the legislation. Sati was defined under section 2C of the 1987 enactment as immolation or burial of a living woman upon the death of her husband. So, as we know, history has suggested to us that Indian women were buried alive after the death of their husbands, or they were immolated on the funeral pyres which carried their dead husbands. So, the practice of sati extended, and the definition of sati as well extended towards these activities. Other punishable acts in connection with the practice of sati was the glorification of sati, abetment of sati and aiding in the commission of sati. So, when we say glorification of sati, what exactly is meant by it? Glorification of sati referred to the organizing of any function which would precipitate the commission of sati. It also meant the practice of abetting the commission of sati by singing of hymns, by calling the woman as a goddess or a divine entity, or as somebody who should be respected because she has been practicing sati. Glorification, in other words, in technical language of the law, meant any kind of encouragement or incitement towards the commission of the act of sati. Followed by the Sati Prevention and Prohibition Act, we then had the Hindu Widows Remarriage Act in the year 1856. Now, the problem of widows in India was phenomenal. They were exploited physically, emotionally, financially, in all forms that can be conceived. And widows had very unique problems because of the analogous practice and the commensurate practice, concurrent practice of child marriages which were happening in India. As a consequence of child marriages which affected men and women both, we got to see that Indian women who were very young in age, sometimes as young as 9 or 10 years old, were married off to men who were more than a decade older to them, sometimes 2 to 3 decades older to them. As a consequence of this, Indian women, you were left either without the consummation of marriage, sometimes with very young children immediately after their marriage, and within a couple of years of marriage, sometimes within a year of the marriage, we had their husbands dying, because obviously the age gap between the man and the woman was very high. As a consequence of this practice, Indian widows used to face severe problems in terms of social deprivation, renunciation. They were looked down upon as individuals, and their social life was a hell, because of the simple reason that their husbands were dead. Remarriage of widows was not conceivable at that age, because widows were considered to be inauspicious, and obviously the idea of piety or sanctity which was attached with the image that they carried impacted the Indian society in a severe way. So we did have to come up with a law during that stage. So in 1856, the Hindu Widows Remarriage Act was born. One of the primary contributions of the 1856 enactment was to validate the remarriage of widows, which was till then recognized as illegitimate. Not only that, children who were born out of such wedlock were recognized as legitimate children. So by conferring legitimacy on the validity of the marriage, as well as legitimizing the children born out of such wedlock, the Indian government at that point of time, the Indian legislature, ensured that the remarriage of widows is considered to be a legal thing. And this is where the journey towards the emancipation of widows in India started. Obviously, then another important piece of legislation also deserves special mention and attention because it is relevant even in the current era. So in the year 1929, we did come up with the Child Marriage Restraint Act. The consequence of and one of the major contributions of the Child Marriage Restraint Act was to ensure that women are not married off until and unless they attain a threshold age. So here the minimum age of marriage was fixed at 18 for women under section 2 of the enactment. Not only that, it was considered to be the legal age for marriage for a woman, as a consequence of which any parent or guardian who got their women or daughters married off before they attained the age of 18 were punished, or such actions were made punishable. So which means by having punitive provisions for the legal guardians of children who had not acquired the age of 18 years, we could ensure at least in the text of law that the practice of child marriages be restrained. It was necessary for the health of our women and obviously something which deserved a special mention. So after looking at the number of laws that had to be enacted just for the purpose of protecting the social status of women, let us now take a look at the most important segment of laws which has a bearing on the life of women. This segment therefore will be a discussion on women and their interface with matrimonial laws. Now, marriage as an institution has played a significant role in the life of a woman. Marriage, as it is seen, has also been linked with the social status of women because not getting married till date poses a problem for a woman. And the worst part about the whole story is that even after one is married, she is not free from the clutches of the evils that come with marriage sometimes. So which means marriage has been considered to be one of those social institutions which has also borne the maximum problems for a woman, because out of marriage or with the institution of marriage are associated many other problems which qualify as legal problems in the life of a woman, which means problems like divorce or termination of marriage, custody battles, property right to maintenance battles, all of these things are associated with the idea of marriage. So for a woman, marriage is a significant institution, and at the same time, this is that institution in the Indian society which is responsible for bringing out the maximum possible number of legal problems for a woman. So we have an entire body of laws for governing the rights of women at the time of marriage, because it was felt by the legislators and there was sufficient evidence to prove that women have to be protected not only in the institution of marriage, they have to be protected for all incidents of marriage. They have to be protected in the domestic setup where they are married into, and along with that they need to be protected during the aftermath of marriage if at all a marriage falls apart. So we have an entire domain of personal laws, and the domain of personal laws carries mixed responses for women and the rights of women. So, let us take a look at the number of laws which the Indian legislature has come up with for the purpose of protecting the rights of women. The first such enactment that I will be discussing with you was passed in the year 1961, the Dowry Prohibition Act. Now, under the Act, the term dowry has been defined, and any payment, request or acceptance of dowry has been made a punishable offence. It is necessary to check the background against which the enactment had to come up. Now, the institution of dowry has for a very long time been associated with the institution of marriage in India. Dowry as a system meant that women, when they were married off, had to carry certain goods with them in the form of valuable securities, in the form of property, either movable or immovable, because they were being married off into a family which considered her to be an economic burden. So, in order to set off the economic burden, parents of women were and still are being made to pay a substantial amount of either money or property to cough up some amount of economic compensation for the fact that a woman was moving into the household of another man. The idea was a woman made no economic contribution to the household. So, which meant, for instance, that even when a woman is rearing the children, teaching the children or cooking for the family, they are never considered to be actions or activities which carry any economic benefits. So, obviously, the Dowry Prohibition Act was necessary or became necessary because women met with a lot of matrimonial violence in the country. Not only that, in their domestic homes, they were sometimes even thrown out of the picture. Not only that, they faced a lot of harassment for purpose of bringing less amount of dowry or more amount of dowry. So, we then have another piece of legislation in the year 2005, which is the Domestic Violence Act. The Domestic Violence Act was a necessary feature of the Indian matrimonial home, because Domestic Violence Act essentially came into the picture for the purpose of protecting women in their matrimonial households. Now, this is something which deserves serious attention, because the concept of domestic violence in India is something which is probably prevalent in many other countries as well. But in most of the Indian households, the women witnessed violence in the domestic sector. Now, this is a form of intimate partner violence or violence which one receives at the end of a spouse or an intimate partner. So, the Domestic Violence Act is a progressive piece of legislation which was passed a couple of years back, and an important or salient feature of this particular piece of legislation is that it not only recognized married relationships or married women as victims, but also recognized live-in relationships. Now, the law was progressive and also catered to the changing demands of society by taking into cognizance the fact that women needed to be protected even when it was a quasi-marital relationship or a marital relationship which had not been recognized or had been rendered invalid. Now, a problem, however, which is associated with the Domestic Violence Act is that it faces severe non-implementation issues, because one of the primary features of the Domestic Violence Act is that it needs to be implemented by protection officers who are in charge of giving protection orders to women. Now, due to non-appointment of protection officers in many parts of India, the legislation has met with failure on several occasions. Obviously, then, when we talk of matrimonial cruelty and matrimonial issues, we cannot do away with the legal provisions which are present in the Indian Penal Code. So, obviously section 498A deserves special mention here. Section 498A of the Indian Penal Code talks about the protection of women in the matrimonial household. So, when we say matrimonial cruelty, what exactly is meant by it? The law under 498A is targeted towards the protection of married women and is targeted against the husband and relatives of the husband. The history of the genesis of section 498A is very interesting because it was noted a couple of decades back that the Indian woman needed the law in her hands when she walked into her into her husband's family, because that is the place where she meets new people, and we have several evil practices in institutions like, for instance, the institution of dowry, where the in-laws have a demand on the family of the woman. So, to counter these situations, it was necessary to arm the woman with a weapon the minute she walked into her matrimonial home. This is where section 498A was conceived of and implemented. So, after section 498A, I think we should also discuss section 304B of the Indian Penal Code, which talks about dowry death. This is obviously a significant piece of law because it presumes that if a woman has died under unnatural circumstances within 7 years of her marriage in her matrimonial home, then the initial presumption is that it is a case of dowry death. Obviously, the death should have certain connection with demands for dowry and other such things, like her being harassed for dowry or her being treated cruelly at the hands of her in-laws. I think when we have discussed the concepts of domestic violence, dowry and evil institutions pertaining to marriage, it is at the same time very important for us to understand another facet which is related to the social life of a woman when she is married, and this is the concept of restitution of conjugal rights. Now, the concept of restitution of conjugal rights has been captured in Hindu law, Islamic law, Christian law, in every other piece of personal law that we have in India. Now, what exactly does restitution of conjugal rights mean? Restitution of conjugal rights is a concept which states that women and men, when they get married, are entitled to the conjugal society of each other. So, a woman can have, or a man can have, rather I think the correct term to use here would be the term spouse. A spouse would have a cause of action against his or her spouse if at all the person abandons conjugal society of the other or denies conjugal society to the other on an irrational or unreasonable ground. The problem with restitution of conjugal rights is it has often been used as a weapon by men to control many activities pertaining to women. So, for instance, there have been numerous judgments which have been delivered by the high courts where women have had to give up their jobs or change the course of their jobs because the requirements of their job were such that they had to stay away from the matrimonial home. So, restitution of conjugal rights as a concept has also been misused in the context of women. Then there are several other provisions for divorce in various personal laws which have been considered to be extremely derogatory to the dignity of women. To cite an example, the system of triple talaq in Islam has been controversial for a very long time. So, the system of triple talaq has been controversial because of many reasons, because as per the system and the way it has been practiced or was practiced at least on many occasions, was that by pronouncing talaq 3 times, a man could renounce his relationship or give up or terminate his relationship with a woman no matter how long the marriage had been. The issue gained a lot of media attention and also created a stir in the country's psyche when the case of Shah Bano Begum came up. Now, an old woman who has sacrificed the major years of her life in tending a family, nurturing a family, suddenly found that the doors of a matrimonial home were shut to her forever when her husband pronounced talaq 3 times on her. The issue is, under the Sharia law, Muslim women upon their divorce are entitled to maintenance only for the period of iddat. Now, the temporary maintenance which has been given to them is not always sufficient, especially when one takes into consideration the issue of long term marriages. That was also the issue with Shah Bano Begum, and obviously we then had to come up with a piece of legislation which brought about a major amendment in the Dissolution of Muslim Marriages Act. So, we have now seen that matrimonial laws have not really been very conducive to women, although attempts have been made to protect the dignity of the woman on many occasions. Now, another piece of law which deserves special maintenance is the Hindu Minority and Guardianship Act of 1956. Let us see if the law has been able to equate men with women in the spirit of Article 14 of the Indian Constitution. Under Section 6 of the Hindu Minority and Guardianship Act, a woman or the mother rather is given the status of a natural guardian only after the father, which means when it is a legitimate child, the law clearly states that the father is the primary natural guardian, and only after the father the mother is the natural guardian, which makes the status of the mother that of a secondary natural guardian, which is questionable because one does not see the reason as to why between parents the distinction of primary and secondary has to be made. Even if it is being made, what is the rationale behind the making of such demarcations? Interestingly, Section 6 also mentions that in case of an illegitimate child, the mother will be considered as the primary natural guardian. So, this brings many questions to our mind. So, for instance, when you talk about a legitimate child, why is it that the father should be considered to be the primary natural guardian? But when it gets down to the level of an illegitimate child, we take the mother for granted as a primary natural guardian. So, the inconsistency of the law is apparent. Whenever there are greater social responsibilities associated, we try to shift them to the woman in question. Then another piece of legislation which deserves special mention is the Hindu Succession Act of 1956. This 20th century legislation, as you can see, came into operation 6 years after the enactment of the Constitution, when the Constitution guaranteed right to equality to all its citizens. Initially, and interestingly so, women were denied equal rights as men when it came down to the distribution of family property. So, which means that in a coparcenary, women could not be part of the coparcenary, whereas men could be coparceners. An amendment was made suitably in 2005 only, where women were recognized as coparceners, which meant that the institution of karta, which gives the status of the head of the family to a person, head of a joint family to a person, or Hindu undivided family, can now also be extended towards women. It is now, after we have discussed the matrimonial laws, it is now important for us to take a look at laws which have been devised to meet the requirements of women at their workplace. So, I think I will begin with the 1976 enactment of Equal Remuneration Act. The act had to be devised because men and women were not treated equally at their workplace. So, when it came down to the question of parity of pay, there were many occasions where a woman was discriminated against on irrational grounds and was not entitled to the same pay as her male counterparts. Now, with the Equal Remuneration Act of 1976, an attempt was made to not discriminate between men and women at workplace and to ensure that equal pay is given for equal amount of work without any distinction or discrimination on the basis of gender. Apart from that, we have certain special enactments on many occasions which cater to the special needs of women. So, for instance, a very special function that a woman discharges in society is that of being a mother, and the same had to be recognized at some point of time in Indian laws for women who used to be employed in enterprises. This is precisely where in 1961 the Maternity Benefit Act came in. Under the Act, special provisions are made for women at workplace when they are pregnant or are with child. So, they are entitled to special regulations in terms of leave, in terms of other occasions. But when you look at the actual implementation of the Act, there are many real life instances where women are either denied promotion or are not really given the same benefits that they are actually entitled to under the piece of legislation. However, in the letter of the law, we do grant women special benefits under the Maternity Benefit Act 1961. I think it would be pertinent here also to mention the case of Vishaka versus State of Rajasthan, where the Supreme Court laid down guidelines for preventing sexual harassment at workplace. So, the purpose of actually mentioning the case was to ensure or to bring to light the fact that women need special protection at the workplace, and on many occasions we have made an attempt to come up with laws for safeguarding them. How far they are being implemented is a different question altogether though. Now, I will get to a very important domain which discusses gender concerns in a very important aspect of law, in a very important discipline of law, which is rather a criminal law. So, in the Indian Penal Code, where we talk of substantive criminal law and basic standards of law demand that there is equality in terms of treating men and women when it gets down to commission of crimes or punishment for crimes. Now, it will be interesting to note, as we will note in this slide, that there are certain provisions which are made in the Indian Penal Code which are apparently gender insensitive. They are not, I think the proper word here would be not just apparently gender insensitive, they are gender insensitive on many counts. So, let us begin with a discussion on the offence of adultery. If you look at adultery laws in India, an adultery is an offence which involves a married woman, because for the offence of adultery to be committed, one must ensure that the woman is married. It cannot be committed against spinsters, for instance. So, while the offence involves a married woman, it is interesting to note that it is a man to man offence, which means the cause of action can be had by the husband of the woman against the paramour of the woman. So, that being a man to man offence, the question then arises, what exactly is the role of the woman here? The law makes a provision that she cannot be even punished as an abettor. Essentially, the participation of the woman in the entire act is seen to be as though something which is as good as non-existent, because probably the legislators felt that for the offence of adultery being committed, the men had an important role to play and not women. This is derogatory to the dignity of a woman, because when you look at it, we treat her as though she is somebody who is not capable of giving a consent, or she is somebody who can just be swayed or can be objectified in the entire act. Not only that, women are not allowed to prosecute female paramours of husbands. So, which means, for instance, when X has sexual intercourse with a woman who is not the wife of the concerned person, the wife here cannot prosecute the female paramour of the husband. which means that when it is in connection with adultery, although the nature of the offense is something which can be committed both by men and women, the women cannot take advantage of the relevant provisions made for adultery in the Indian Penal Code, and this is something which is obviously not in the interest of women. First, we do not punish them as abettors, we do not punish them as participators in the offense of adultery. So, that is how we look down upon their status, because we conceive of them as individuals who cannot give their consent to the sexual act. And secondly, and most importantly, we do not allow them the privilege of prosecuting their the female paramours of their husbands. Section 377 of the Indian Penal Code is another area wherein we need to take a look at how the law approaches gender concerns. Now, in the country today, we have transgender identities, gay, lesbian identities coming up and not being recognized. Not only that, the Indian Penal Code penalizes any actions which are sexual in nature and are confined to gays, lesbians or transgenders. It not only de-recognizes homosexuality, what we are doing is even more vital. We are trying to criminalize homosexuality, and that is one area which deserves special attention, special mention. Another major area which became very prominent after the Nirbhaya episode is the provision for rape in Indian Penal Code under section 375. Initially, the definition of rape included only penile penetration and was not something which could include oral penetration. However, after the amendment, major amendment which was made in the year 2013 to the Indian Penal Code, we now recognize oral penetration, which was formerly not recognized as an action of rape. Not only that, we have also increased and widened the ambit of rape and sexual assault, and have come up with several such new offences or actions which are liable of being penalized, like voyeurism, stalking, etc. However, the fact that we did have to wait for something like as grave as the Nirbhaya episode, as brutal as the Nirbhaya episode, is something which does raise eyebrows. I would then like to mention the very special case of partial defense under the Indian Penal Code in the chapter on general exceptions, which makes grave and sudden provocation a partial defense, but does not recognize the battered woman syndrome. Now, as we know, grave and sudden provocation is something which men are more prone to, because it is a part more of masculine psychology than of feminine psychology. So, while women react very differently to a given situation than men, it is something that we should have taken note of. A battered woman syndrome, which came up in the case of Ahluwalia, is something that deserves special mention, because women do tend to react in terms of having pent up emotions for a very long time and then suddenly reacting in a very violent way to a stimulus which may have been very harmless. So, I think that is one area where we can think of including the battered woman syndrome as well as a partial defense. Now, before I conclude, it is important for me to point out certain very important provisions that we have discussed. So, the most important thing that I would like to mention is many of our laws are obsolete and not really very women friendly. At the same time, many beneficial legislations have come into the picture to protect women. But how far they are relevant and for what period of time we had to wait for them coming into existence, it needs to be scrutinized. So, before something as gruesome as Nirbhaya takes place, I think it would be better if we have an amendment, as in I presume it is better to have an amendment. It would have been better to have an amendment before 2013 and not wait till something like the Nirbhaya episode. Then I would like to mention that law is an agent of social change, and therefore, it will have a significant impact on how the perception of society changes towards them. So if we have laws which are women friendly, obviously it will play a role in changing our attitude towards them. As we conclude, I would like to summarize some of the important points that we discussed in the slides and throughout this lecture. So, laws, society and concerns for gender are intertwined. Women have faced disabilities in the past and therefore, they need special protection. The Indian Constitution enshrines the spirit of equality, which means that women must be treated at par with men. Indian laws have been formulated sometimes to meet the special requirements of women, but mostly women have had to face discrimination in connection with the legal system. Women face discriminatory treatment in connection with several laws, particularly in connection with matrimonial and penal laws. Sometimes special laws are enacted, but their benefits are denied to women due to lack of implementation facilities. So, like I mentioned in the earlier slide, an example of this would be the DV Act of 2005. On these counts, Indian laws fail to remain genuinely gender sensitive and therefore they require reforms. So, before I conclude, I would like to mention this one very important point in connection with Indian laws. We as a society have gone a long way thinking about the rights of men, thinking about the privileges that can be extended to them, but we need to realize that women need to be treated at par for any society to survive, to be nurtured, to grow and to develop. This is where the orientation of law in Indian society must also change towards an attitude of sensitivity. Thank you.